Well, many of you are weighing in on 41NBC.com about Judge Howard Sims and his recent run-in with the law. He was stopped on September 22nd at a roadblock, and officers found he had a blood alcohol level of .083, but he was allowed to drive home. Now, the Bibb County Sheriff's Office is saying deputies did not follow proper protocol by just letting Judge Sims leave. We've received a lot of feedback from you saying Sims received preferential treatment because of his position. Gary says, enough of the double standard for Georgia law enforcement. This makes the Georgia judicial process look very corrupt. David Sullivan writes, he was intoxicated, but he received preferential treatment due to his position. The average citizen would have been arrested and not allowed to drive home with an escort. Joining me to talk about this case is our legal expert, attorney Jay Davis. So Judge Sims had blood alcohol level of .083. In your experience as a lawyer with DUI and things like that, are people normally arrested for that, or what's the deal?
Well, this is a roadside Alka-Seltzer, apparently, is what he registered on. Those are not legally binding. They're not going to be able to be used in the court of law. The result that's weighed is the result that's at the station, and that's with the intoxilizer, and that result can change very significantly from what might be on a roadside. It's very possible somebody might test high on a roadside if they just drank a couple of beers, 2 beers real quickly. Most people say 2 beers when they're stopped. Everybody's quick to say that. That'll actually get you a .08 or .083 possibly.
So say he could have had he had this blood alcohol level, but by the time they were to get him to the police station or wherever,
if something
it would have gone down.
Spikes it. If you just recently had those 2 beers, you could test pretty high. And by the time you got to the station, you might be at half that level because it's registering because of the recent alcohol in your mouth.
Well,
and then if it's been several, you could be going up. You could be at a point where it's .083 and it's going up, or it could be .083 going down. But .08 is the legal significant level.
Well, there's a big internal investigation going on right now to see whether those officers should be punished for not detaining him. But from a lawyer's perspective, should he have been detained with that amount of alcohol?
If it's possible that protocol would say yes, but from a lawyer perspective, I'd say maybe not. If the police determined that he possibly was going down, if he said and they believed that it was a couple drinks that he just had right before that, and they believed that that was it and the limit, they could believe that by the time they got him there that it wouldn't be significant. I'm not sure whether or not he was escorted home or driven home or allowed to drive, but normally they would not let you drive.
The report that we reported yesterday that he was followed home, so the police were monitoring him as he was driving. But should they have done the standard field sobriety tests, like the walk test, the eye test, things like that?
Those tests are required if you're going to arrest somebody for DUI. If you've determined based on a conversation or based on something that you don't believe the person is intoxicated, or don't believe that it's to that level, then they didn't have to. They weren't obligated to. Now, would that be a normal thing to do? Probably so.
Well, bottom line, don't drink and drive.
Bottom line.
That's the final. That's the final.
If you drink, don't drive.
All right. Thanks so much, Jay. And the Bibb County Sheriff's Office has announced that a news conference is set for tomorrow afternoon to discuss this case. 41NBC will be there, and we'll bring you the details. And if you'd like your legal questions answered, all you got to do is send us an email to itsthelaw@41NBC.com, and we will answer it right here on the air.